Hi guys, welcome back. I hope you found the first video useful. The following covers section B of paper 1. It's all to do with criminal law. Let's get straight into it. Firstly, there's some important key terms that come up quite a bit throughout this topic, so it might be worth taking a note of them down if you don't know them. So, firstly, we've got recklessness. This is taking an unjustified risk, as shown in Gemmell and Richards. You've got direct intent, which means the desire/aim for outcome as a result of actions, which was shown in Mohan. You've got oblique intent, where the outcome is unintended, but it's a foreseen to a virtual certainty, as shown in Nedrick. Negligence is the failure to exercise appropriate and or ethical ruled care expected to be exercised, as shown in Woolen. You've got Actus Reus, which means prohibited act. This includes like conduct, offences, circumstances, and consequent. Then you've got mens rea, which means guilty mind. The first topic on the section B spec includes general elements of criminal liability. Now there's two sides to this. You've got the actus reus and the mens rea that I'll come to later. Now in actus reus you've got causation, where there's a factual test and a legal test. For the factual, you've got the but for, as shown in white, and you've got the legal test, where you can pick from any of these two, the Cheshire's significant contribution or Smith's operating and substantial cause. You've also got the novus actus interveniens, where it could be a victim's own act, as shown in Roberts, act of a third party, as shown in Williams, or a medical intervention, which is shown in Jordan. Now, any of those can be used to break the chain of causation. In an exam, you must be quite specific about what one is being used in the scenario. Next, you've got the thin skull rule, where you have to take the victim as you find them, which was shown in Blau. Then you've got omissions, which means failure to act. Now currently in the UK, there's no Good Samaritan law. There's an exception in the Hillsborough victim Airedale NHS Trust v Bland, however. There's also exceptions created by statute and case law, creating a duty to act and a failure to do so a crime. For example, breath test, Road Traffic Act 1988, and failing to look after a child under the Children and Young Persons Act 1933. Now the 6 exceptions by judges that will most likely come up in an exam are firstly contractual duty. Now it's good to remember a case for each one of these. So you've got Pitwood, you've got the statutory duty, which is Reed, the duty because of a relationship, Gibbons and Proctor, duty taken voluntarily, Stone and Dobinson, duty through one's official position, Dypham, and failing to prevent a dangerous situation from which he started duty, Miller. Moving on to the general elements of mens rea. Firstly, you've got coincidence, which is also known as the contemporaneity rule. So the law is quite flexible here to the general rule. This is to secure convictions. Some crimes might count as a continuing act. This is where they had the AR and the MR at some point. This was shown in Fagan. And some crimes, they might be classed as a series of linked transactions, as shown in Fable-Melly. This means they had the AR and the MR present at some point along the link. It doesn't have to be the same time. Then you've got transferred malice. This is the principle that a person can be guilty of an offence if they commit the actus reus of an offence and have the mens rea for that offence, but the mens rea is aimed at someone other than the victim. Now, a good case for that is Latimer. You've also got strict liability, where you only have an AR. It's usually a public situation crime, for example, motoring. It's only usually minor and punishable with a small fine. There was an exception, however, in the case of Gammon v AG Hong Kong. strict liability crimes are never real/moral crimes and are always created by Parliament, not judges. Now, if it's unclear if the crime is strict liability or not, then it will not be, as shown in Sweet v. Parsley. The first fatal offence is murder. Now, the definition for murder comes from Sir Edward Coke, 1797. His definition was that it was an unlawful killing of human being under the Queen's peace, with malice aforethought, express or implied. Now, some of those words are quite outdated, so the following might be quite helpful. So, for AR, you've got unlawful killing, which means not in more conditions / self-defense. You've got human being. This means a baby breath independent of the mother. This was shown in AG Reference 3 of 1994. You've got Queen's Peace, Blackman, which was a war killing. And then you've got the usual rules of causation. Under MR, you've got malice aforethought, express or implied. Vickers is a good case for implied. You've got issues of direct, Mohan, or oblique willing intent. So express means intended to kill, and implied means intended to cause GBH. Next, you've got voluntary manslaughter. Now there's two VMs that you need to know about for the exam, the first of which is diminished responsibility. This comes under Section 52 of the Coroners and Justices Act 2009, which was amended by the 1957 Homicide Act. Procedure is on the balance of probability. Now, test 1 for DR is that the D must have an abnormality of mental functioning. This is a state of mind so different from an ordinary person that they would deem it abnormal. Good case for that is Byrne. Test 2 is that it was caused by a recognised medical condition. This could be recognised on WHO's list. Then you've got test 3, which is it must have substantially impaired D's ability to do one of the following. Now you've got A, to understand the nature of D's conduct, B, to form a rational judgment, and C, to exercise self-control. Then you've got test 4. It provides an explanation for D's part in the killing. Now Deichmann is the case to go on that one. It's quite easy to remember. It was just a savage attack from grief, depression reaction. The second VM is loss of control. This comes under Section 54/55 of the Coroners and Justices Act 2009. This is when an ordinary and reasonable person can, if faced with extreme circumstances, lose their self-control and kill. So test 1 for this is a subjective question for the jury to decide by looking into D's mind to see if control was lost. Now Thornton is the case used for this. Test 2 is to see if there's been a qualifying trigger of both or either fear and anger. Section 55, trigger lost if loss of control, not result of trigger, if threat isn't of serious violence, if threat not from D. For example, Doughty, a baby crying, wasn't considered provocative. And in Clinton, not sexual infidelity. Now test 3, you've got objective test. Now if a person of the same age and sex with a normal degree of tolerance and self-restraint would have acted the same / similarly under the circumstances given. Section 54(3) requires all these circumstances to be taken into account. This is a contradictory piece of law as it expects people to show a normal degree of control. AG Jersey v Holly replaced the reasonable man test. The opposite of voluntary manslaughter is involuntary manslaughter. So for IM, you've got unlawful and dangerous act, which is also known as constructive manslaughter. Test 1 for this is there must have been an unlawful criminal act. Now this doesn't necessarily have to be directed at the V. This was shown in Lamb, where there was a revolver incident. Um, it must be an act. It can't be an omission, like in law. For test 2, the act must be dangerous. This is an objective test. The case for this is church. It's where a sober and reasonable person would realise risk of some harm. So it doesn't matter if they didn't realise. Test 3 for UDA is causation. Now, the usual rules of factual and legal apply, but the case for this is Watson. Test 4 is mens rea. So the deed doesn't need to intend death, they just need the MR for the act. This was shown in Newbury and Jones, where there were boys throwing stones off a bridge, and one of the stones unfortunately hit a train driver. Then you've got gross negligence. Now, test 1 for GN is there must be a duty of care owed. So like in Donahue v Stevenson, the Snell in the ginger beer, and Becker, so a doctor-patient relationship. Test 2 is that there must have been a breach of duty of that care. So this is when the conduct falls below the standard of an ordinary reasonable man. So the jury decides, and it must be a serious enough breach. So like in Adamaco. Test 3 is that it caused death. The usual rules of causation apply again, but the case for this is R.V. Wacker. This man had a lorry full of immigrants, and I think they suffocated actually, because they had no oxygen. Test 4 for gross negligence is there should have been a risk of death, as in saying the reasonable and prudent person must foresee the obvious risk of death. You can also use MISRA for this. This is where V died of toxic shock and ignored clear signs and risks. Test 5 is there must have been gross negligence. I know that seems a bit silly, but yeah, that's a test 5. Bateman is used here. The negligence went beyond compensation and showed disregard for the life and safety of another. Moving on to non-fatal offences against the person, you've got the offence of assault, which has a maximum sentence of 6 months and or a 5k fine. Now this is found in section 39 of the Criminal Justice Act 1988, also the CJA 1988. Now the AR for this is to cause V to fear imminent unlawful harm, and the MR is intention or recklessness as to. Now there's loads of cases you can use for this. My favourite is Smith v Superintendent of Woking Police. It's just what you remember easiest. The next offence is battery. Again, you've got the same max sentencing. It's also found in the same CGA, section 39, 1988. The AR, however, is a little bit different. It's to apply unlawful force to the body of another, and the MR is the same. Case for this is Collins v Wilcock. The next offence is ABH. You've got a maximum of 5 years for this offence. Now the source for this comes from section 47 of the Offences Act against a person, 1861, so you can refer to it as OAPA. This is an assault or battery that occasions ABH. Now for the MR, it's intention or recklessness as to an. The case I use for this is DPP VK, or Chanfux, just as good. You've also got recklessness. You've also got reckless GBH/wounding with a maximum of 5 years. Now this comes under section 20 of the OIPA 1861. The AR of this is to wound or inflict GBH, serious harm, with or without a weapon. Now the MR is unlawfully and maliciously to some harm foreseen. The cases used for this is Bodham and Eisenhower. The next offence the last one is intentional GBH/rendon, and the max for this is life. This comes from Section 18 RIPA 1861. The AR for this is to wound or inflict GBH or resist arrest. The MR is to unlawfully and maliciously with intent cause. Cases, you can use the same cases for this, or you can use Morrison and DPB v Smith. The next topic area is property offences. So the first one is theft. The Theft Act 1968 is where theft is sourced. This is to dishonestly appropriate property belonging to another with the intention to permanently deprive the other of it. So Section 2 is dishonesty. So these are like the tests for theft. So Section 2, dishonestly. The case of R.V. Gosh established tests used to prove/disprove dishonesty. This is where a doctor claimed fees for a surgery he never did because he thought he was owed it. Now you've got the objective side, which is the ordinary standards of reasonable and honest person, and the subjective, which is not used anymore since I.V. Gentin case. Also, there's like a little exception where you're not dishonest if at least one of the following are met. Belief in the right of law to deprive the other of it, belief he would have consent, and if the defendant took reasonable steps. Section 3, kind of a test 2, is appropriation. So assuming rights of the owner, which was shown in R.V. Gomez with the shop cashier who accepted stolen checks. You've also got Section 4, which was property. This was shown in Oxford and Mott, who looked at test papers before the exam. So property includes money, personal property, things in action, intangibles. Now it doesn't include land or things forming part of land. You've got Section 5, belonging to another. At the time of the appropriation, it belonged to another, so the possession/propriety interest. This was shown in R.V. Turner, who took a car from a car repair shop without paying. There's a little subsection 3 where it says it has to be dealt with in a particular way, and 4, not taking steps for restoration/deprive. Section 6 is with the intention to permanently deprive the other of it. This is to treat the thing as his own to dispose of, regardless of the other's rights. That case, I can't say that. Also borrowing or lending, as seen in Lloyd. Also got robbery. This comes from the Theft Act, Section 8, 1968. The AR and MR of theft are used in robbery. You've got R.V. Robinson, who says no theft, no robbery. The AR is using or threatening force immediately before or at the time of theft. So, like in R.V. Howe, continuing appropriation, where D tied up V while stealing from his house. The force must be noticeable. It cannot be a threat for the future. Also, jostling counts as false, as seen in Dawson v. James. There must be a connection between the force and the theft, so it must be used in order to steal. For MR, intent or recklessness as to the use or threat of force in order to steal. Lastly, you've got burglary. This comes from the Theft Act, Section 9, 1968. So there's like two parts to this offence. You've got Section 9(1)(a), called Offence 1, basically, and it's for entering any building/part of a building as a trespasser with intent to commit any such offence mentioned in Section 2. And Section 9(1)(b) is having entered a building/part of a building as a trespasser, he steals/attempts to steal anything in/part of the building or inflicts GBH. So, some of the common elements, you've got you've got enters. Is enough of D in the building to commit/attempt RV Ryan. Common element 2. Building/part of 1. It must be a permanent structure. Substantial portables can be classed as robbery. RV Walkington. Shop counter till. You've also got trespasser. Intentionally or recklessly enters in possession of another without the right to do so. The entry must be voluntary. If they have permission to do so, they can enter. R.V. Smith and Jones, who stole from a father. The MR of the first offence. The MR, the MR for offence/attempted offence required before entering. And for the second offence, having required MR for offence when he commits it, he doesn't need the MR for the offence at the time of entry. Moving on to mental capacity defences. Firstly, you've got intoxication. Now there's two parts of this. One of them is involuntary, which is a complete defence to all the crimes, or voluntary, where D intakes too much alcohol, drugs, solvents, and is of limited application. So there are principles to prove for a successful intoxication plea from the defence. So, for example, the VI is a defence to specific intent crimes, RV Beard, not to basic intent crimes, RV Majewski. It doesn't add to the defence for D to not know the strength of the intoxicating substance, as found in RV Allen. The person must be so intoxicated that they cannot form the mens rea of the offence, RV Kingston. The position is the same whether the intoxication is caused by drink/drugs, RV Lippman. However, sedatives are not treated as reckless, RV Hardy. The effect of pleading the defence to specific intent crime is to reduce crime to basic intent, so the defence is not available to basic intent crime. Also, you might come across a Dutch courage rule exception. You probably won't, but you might want to make a note of that. It's from the case of RV Gallagher. It's basically if your aim is to get drunk to commit an offence. That's not a defence. Next up is insanity, aka insane automatism. This is sourced from the McNaughton Rules, 1843. You must have a disease of the mind, a defect of reason, and the D must or didn't know the nature and quality of his act, or did not know that it was wrong. So the principles to prove are that D was suffering a disease of the mind. Lord Denning in R.V. Bratty said any mental disorder which manifests itself in violence and is prone to reoccur is a disease of the mind. Some of the case examples are Sullivan, Hennessy, and Burgess. The second principle is a defect of reason. It's caused. D's power of reasoning must be impaired. So I've used Clark as a case. The defence failed here as she had powers but failed to use them. The third kind of principle is split into two. So firstly, you've got the nature and quality, as seen in Codir, who thought his wife was a loaf of bread and appreciated the act was wrong. B, so Windle said, I suppose I'll hang for this, indicating he knew his actions were wrong. The outcome of a successful plea means a supervision of treatment order. For automatism, Bratty says this is involuntary acts done by the muscles, so you've got no control of the mind. Test 1, there must be a total loss of control, or D must act involuntarily. So cases for this include Hill v Baxter being the main one for the total, and Brim v Perkins for partial. Then you've got test 2, the cause of the automatism must be external. So cases for external include Quick, diabetes injection, and for internal, Hennessy, who had diabetes and didn't control his diet properly. For the defence of consent, the AG Ref 6 of 1980 says the defence arises when V has consented to injury that D has caused. This is limited on public policy grounds, as it's not in the public interest to cause injury for no good reason. This means it's not available for assault or battery cases, only for crime where harm is caused if the activity falls within one of the recognised exceptions. So Brown is the most commonly associated case with consent. So for test 1, is there an injury? If the answer is yes, you need to examine the activity that caused it, and if not, consent is available. Test 2 is a list of the accepted activities for consent. So, i.e., is there a social benefit? So this can include sport, surgery, horseplay, R.V. Jones, beautification, R.V. Wilson. Test 3, is consent valid? So fraud, capacity, threats, all of these can make it invalid. Some cases include Richardson and Tabasson. You've also got duress of circumstances. Martin, driving whilst disqualified, Dee believes that he or she, or those with him, would suffer death or serious injury if he did not escape by doing what he did. So, essentially, the crime must be committed to avoid a greater evil. The action can only be taken if the threats are sufficiently serious, like in Conway, who drove off recklessly to escape 2 men who attacked a couple of days beforehand. The crime also must be reasonable and proportionate. It must be a proportionate response to the evil threatened. You can use Bell there. There must be objectively effect of threat seen by D. The reasonable man and D can have bone characteristics attributed to him. R.V. Carnes reaffirmed the circumstances judged as D believed them to be. We've also got defence of duress by threats. This is a full defence apart from murder/attempted murder. For the nature of the threat, the person to whom the threat must be directed, Shayla. The threat must be of serious physical violence, Cole. The type of crime must be specified, Hassan. The threat must be imminent, so D must have a safe avenue of escape. So use Jill for that one. And for the effect of the threat on the D, it must be that it would overpower a person of reasonable firmness. So, for example, a Bowen, a low IQ, thought they would have got petrol bombed. The Graham test is used. It came from a case where D felt threatened, took drugs that helped murder gay lovers. Number 1, it must be a reasonable belief. Number 2, good cause to fear. And 3, a sober person of reasonable fairness. So those are the tests for the Graham test. People excluded from pleading duress include people in gangs, criminal enterprises, like in RV Alley, treason, drug dealing, murder. It's good to know some of the information about some of these cases. I know I've just kind of skipped through them, but if you can put some of these down, some of the information down in the exam, it might be good. You've also got the defence of self-defence. Now this is sourced from the Criminal Law Act 1967. Test 1 is that there must be necessity for action, so the use of force is not justified if not necessary. However, this is subjective. You've got 1A, so mistaken belief. A mistake that leads to them believing the circumstances make defensive action necessary. So this was seen in Williams, who hit a youth attacker, making a citizen's arrest. You've also got drunken mistake, 1B, assessed on D's beliefs of circumstances, even if not reasonable, O'Connor. You've got 1C, preemptive strikes, D, possibility of retreat. However, it's not necessary to do so. This was seen in Palmer. You cannot weigh the nicety to the exact measure, and 1E, self-induced. Test 2 is what's reasonable balanced by the amount of force against harm sought to prevent. So it has to be objectively reasonable and proportional in the circumstances. So for excessive force, I use the case of We Know, because it's quite easy to remember, because he strangled his girlfriend. And reasonable force cases, I just put Scarlett down. Moving on to preliminary offences, attempts. The main source of this offence is the Criminal Attempts Act 1981. If with intent to commit an offence to which this section applies, a person does an act which is more than merely preparatory to the commission of the offence, he is guilty of attempting to commit the offence. So AR, doing an act that's more than merely preparatory, so gone beyond preparation. So the case to use for this is Campbell, who took a imitation gun to a post office, but he changed his mind and walked away. For Emma, the D must act with intention to commit the offence. So Wybrow, who wired up a soap dish to his wife's bath, but ultimately it didn't work. But he was still charged with it. The intention for attempted murder must have been intention to kill, not GBH. So impossibility, section 2, they still may be guilty if commission of the offence is impossible. So it's Shiv Puri, who had a suitcase of cabbage leaves instead of weed. Now it's important to note, you can get the same penalties as the actual crimes, even if the defendant didn't commit the actual crime. Now that I've covered most of the topics, I'm going to have an evaluation section for all of the offences and things we've talked about. So, starting with theft, for appropriation, the width of the acts which can be considered as appropriation, Morris' assumption of rights, gone beyond what is intended by Parliament, appropriation being regarded as occurring at one point in time, like in Gomez, the difficulty to appropriate even though the owner has consented to the act, reliance on dishonesty to prove theft, as its only distinguishing point due to problems with appropriation being too wide. In addition, evaluating property belonging to another, the phrase has caused confusion, as seen in Turner. Evaluating dishonesty, Professor Guru says it leaves too much to the jury, which causes inconsistencies. It places too much emphasis on objective views of what is dishonest rather than D's intentions. And for the Gosh tests, they are longer and more difficult trials, so they're kind of unsuitable in specialised cases, as seen in Ivy Genting. And the idea of standards of an ordinary and reasonable and honest person is unfair. For intention to permanently deprive, if someone dishonestly thieves, does their intention really matter? However, it's easier to convict. Looking at the evaluation of robbery and burglary, the theft element in it is not really treated the same. So for robbery, a continued appropriation has to be proved for theft. However, for theft, the theft has to only be at one point in time. A completed theft should not be necessary, therefore. Also, the level of force required is very low, or maybe too low, it can be argued. Anomalies between 918 and 911B burglary. So B, there is an intention, and A, there has to be intention. So it's kind of inconsistent. The level of damage required is very low. So injury GBH, property above people, that could be argued. There's a lack of definitions, so entry, building, trespasser. Collins in the Court of Appeal said there had to be an effective and substantial entry, although they discarded substantial in Brown. So this kind of shows um, the lack of definitions not really helping the court system, and it's leading to inconsistencies and uncertainties. Moving on to the evaluation of murder, the law has developed bit by bit, so individual cases, and it's not a coherent whole. There's a lot of confusion over the meaning of intention. For example, indirect, direct, oblique. Also, virtually certain is basically the equivalent of direct intention. They can be convicted of murder even if they only intended to cause serious harm, so may not even realise death could occur, but just as guilty. Also, there's confusion over what is serious. There is no defence available if excessive force is used in self-defence. Looking at the last evaluation point and reform of murder, the mandatory life sentence and the Gov's sentencing guidelines do not allow sufficient differentiation in sentencing to cover the wide variety of levels of blameworthiness in the current law of murder. So looking at the reform, you could revert back to the Homicide Act 1957 or something similar for MR of murder being intent to kill. This would be more fair. Also, the Law Commission said they should split murder up into two separate offences, so first and second degrees, kind of like what the US system do. So the mandatory would only apply to the first, second discretionary. The evaluation of involuntary manslaughter, unlawful act. This covers a wide range of conduct. So a voluntary act can be as minor as pushing V, or it may just be short of murder as an unlawful killing, but you're still unable to prove mens rea. The level of blameworthiness can vary enormously, so it's hard to achieve appropriate offence. The death is an unexpected result. In many cases, it is unexpected result of D's conduct. So, as in Mitchell, a D who didn't realise there was a risk of injury to the victim is still guilty of manslaughter because of the objective test. This contradicts the idea of recklessness used in other offences. It must be shown D is aware of the risk. It's inconsistent that this serious offence requires a different form of MR. For gross negligence, the test is circular, as the jury is directed to convict if they think the conduct was criminal, so there's no sequence of reasoning. The test may lead to inconsistent verdicts, as it depends on what different juries think. Juries decide the questions of law, usually just facts, as the judge would do that normally. The civil test for negligence should not be used in criminal cases. The purpose of the two branches of law is quite different, as seen in Stone and Dobson. It's just not developed in the same way. So this is uncertain, what leads to uncertainty. Also, you have to account for the risk of death. It's unclear whether risk had to be of the death or whether risk of serious injury was sufficient. This is to prove gross negligence. The Court of Appeal took risk of death into consideration. Reform for UDA, you could have first and second degree murder and manslaughter, as mentioned before. You could also have a subjective test instead of the objective to prevent the issue. Also, blameworthiness corrected, more serious situations classed higher, greater differentiation allowed. For gross negligence, the Law Commission said the risk must be to cause death. The risk of serious injury is not sufficient. Pass jury questions back to the judge, as he's more qualified, or she. This would lead to more consistent and fairer verdicts. The evaluation of voluntary manslaughter. So first up, I've got diminished responsibility. So for starters, the burden of proof shouldn't be on the D. Most other defences, D only has to raise the issue and the prosecution has to disprove it. It should also apply here because they're at a disadvantage, e.g., they're not faced by those in the LOC. It's a possible Article 6 breach as well because they're presumed innocent until proven guilty, as D has to prove DR guilt. You could also argue developmental immaturity. Lord Conn said it should be included within definition for under 18. Self-control, development of the brain, evidence these doesn't mature until 14. DI not the same as learning disability. The law doesn't recognise this key difference, e.g. murder from child. You can't use DR defence under existing law as they're not suffering from an abnormality of mental functioning. For loss of control, it no longer covers sexual infidelity, so it's not a qualifying trigger for the defence. A fear of serious violence is not enough anymore. The D must also show a loss of control. There's like a very high threshold for this, for allowing it in response to words/actions. It narrows substantiality, potential availability of defence. It also does not cover situations where a woman in an abusive relationship kills through a combination of anger, fear, frustration, and a sense of desperation. A reform for voluntary manslaughter include, for DR, the Law Commission said modernise the definition of DR to take into account changing medical knowledge. So, for example, the 2009 Act recognised medical condition, and for loss of control, I said abolish provocation. For self-defence, evaluating excessive force, you could say lethal force is acceptable in some situations. Reasonableness of force is determined by juries, and this could lead to inconsistencies. Who has the right to take a life? Are we know. Preemptive strike. People are allowed to use this defence a lot for hitting first, claiming it was self-defence when they could be lying. R.V. Beckford. Is force even necessary? Does the law not expect the V to retreat? Burden's CJIA 2008 state no. The defence is too generous to the D. Ds usually get to use it. Even Ds who make mistakes may not get the defence. R.V. Williams. For reform for self-defence, allow excess force to reduce murder to manslaughter. Preemptive strike, more specific rule, they can only strike first if the force is going to cause death if not used. Specific tests for mistakenness must be by a reasonable person. And is the force even necessary? It's decided by juries. You have to accept inconsistencies, as usually quite obvious and easy to figure out. For evaluation of duress, the defence is not allowed on a charge of murder or attempted murder, like in R.V. Howe. If duress is not allowed for murder or attempted murder, then why is it available for the Section 18 charge? The D's IQ is not taken into account. So Bowen, a very low IQ can mean a failure of test 2, as they don't share the reasonable firmness as the normal person would. The defence is not available if D has a safe avenue of escape. Hudson. It's not always best, as it could make the situation worse in the long run. Also, police protection is not always the best thing to get. Like in Hassan, people who could call police but don't may not get to use the defence also. Depending on the circumstances, it could cause juries confusion and inconsistencies. For reform, the Law Commission 1993 report recommended duress is made available for all crimes. It could take into account a person's IQ, as this can be a real reason for acting on a threat. The Law Commission, all characteristics considered accounted for. Uh, you could also abolish the police call rule. It gets rid of confusion for juries. For insanity, um, the broad definition of disease of mind includes epileptics, diabetics, and sleepwalkers, yet excludes psychopaths like Byrne, who might more reasonably be considered insane. Secondly, there's a burden of proof on the D to prove on the balance of probability that his conduct was involuntary due to the disease of mind. This is quite confusing and difficult for a jury to understand, especially if both insanity and automatism are raised. Also, they're quite closely linked, so people may not get the required help. Public policy issues. So, protection of society, continuing danger theory, Bratty, is considered more important than any rights that D may have. The law can be unfair here. It's a difficult balancing act to manage both the protection of the public and justice, fair disposal, sentence for the D. Also, expert medical evidence is required, but this can conflict sometimes, as both DMP argue different points. It's again confusing for the jury and difficult to understand. For reform for insanity, the 1953 Royal Commission on Capital Punishment extending the McNaughton rules to include those incapable of preventing themselves from committing an offence. So this would include Byrne and irresistible impulses. The McNaughton rules should be modernised as they're very outdated. Also, the Butler Committee 1975 recommended that the wording should be changed to not guilty by reason of mental disorder. It's fair on the D, taking into account their circumstances. They can't be at fault guilty for something they did involuntarily. For automatism, at what point does a partial loss become a total loss of control? It's difficult to tell. The loss of control must be total. Expert medical evidence is required, but this evidence again will conflict. If the verdict, or the defence rather, is successful, this can lead to a complete acquittal. It means potentially dangerous Ds running free. This might be seen as unsatisfactory. Public policy issues. These rights are placed above protection of society. It's actually the reverse situation in insanity. It means the law in this area can be dangerous in innocent members of the public, potentially put at risk by allowing a complete acquittal. Reform includes a draft criminal code 1989, which suggested definition to be widened to include epileptics, sleepwalkers, for example Sullivan and Burgess, also including a supervision of treatment orders, so potentially dangerous complete acquitters don't pose as a public threat. Evaluation of intoxication defence. So the development of law via judicial precedent has confused distinction between basic and specific intent offences, so the law is inconsistent and uncertain. For example, in Caldwell, the MR intention distinction to recklessness, and for Heard, the purpose test reclassifies worse offences to basic intent for public policy purposes, so the juries struggle and there's increased subjectiveness. Secondly, there's no lesser fallback offence for some crimes that D can be convicted of. For example, voluntary intoxication. It's a partial defence, if not MR, which is not allowed. Gallagher, e.g. SI murder, basic intent manslaughter, but theft, burglary are complete acquittals, so it doesn't really promote justice or protection of the public. The fallback principle, Lippmann. The Majewski rules say D will be guilty simply for taking drink drugs. The Law Commission say this is unfair, it's harsh. Also, it's unforeseeable as it ignores the AR and MR crimes. It ignores they must coincide. It's quite contradicting, therefore. Also, lastly, an honest mistake with criminal damage is allowed. This kind of lacks consistency. For reform, the 1993 Law Commission said to abolish the Majewski rules, proposing new criminal intoxication. It would better reflect E's responsibility for the crime committed, while VI and is fairer as their harsh rules. Also, in 2009, the Law Commissions said to abolish terms specific and basic intent. A new set of rules could be uniformly and consistently applied. A new trial procedure where intoxication has to be proved via presumption until proven otherwise. Lastly, intoxication and mistake, make it harsher and stricter. Don't allow to make it more consistent. For consent, one sticking point is euthanasia and how it's illegal right now. Many feel the law is outdated here and should change. People should have the right to end their life, it could be argued, and it violates UN human rights that they cannot. You can use Airedale NHS Trust v Bland again here. Intention, consent may be present but not be sufficient if the aim of the activity is to cause harm. There's no social benefit. For level of harm, despite genuine consent, a D who causes serious harm may still be liable. So Leach, this was kind of highlighted. For protection, the need to protect the vulnerable raised issues with consent. Burrell v Hamer, tattooed kids. However, it's inconsistent as the UK showed the UK failed to provide adequate protection. For reform of the consent, make euthanasia legal. The threshold for injuries to which consent given should be raised, and battery defence to exclude acceptable everyday contact. Now that brings us to the end. Sorry about the last bit, I know it was a bit dull, but it'll probably come up in your exam, so it's good to know all of the evaluations. If you got any questions, just leave a comment. Thanks for listening.